Well, another big attendance for the FIDIC Users Conference. It seems that however tough things are in the construction industry, there's a continuing appetite for FIDIC-related material. How do we explain that?
Oh, I think the reason for that is clear. FIDIC is the most widely used form of international construction contract. It's got a long use in various regions across the globe, ranging from the Middle East to Central Eastern Europe and to Asia. It's also used in a wide variety of industry sectors, ranging from the use in high-rise buildings through to nuclear power plants. If you come to a contract conference like this, you will get cutting-edge information from leading industry experts that you can't get anywhere else. That's why people come.
Your session this year is arbitration and dispute resolution. The received wisdom has always been that difficult economic conditions generate conflict. Does that apply to major international projects of, say, several years' duration?
I think you have to draw a distinction between the mega projects that you are talking about and the more normal or routine projects, if I can categorize them in that way. If you take the more usual type of projects, I do think that the received wisdom holds good. Those contracts were tendered aggressively, and the contractors need to make claims, especially now in these hard economic times. When you look at the major international projects, I do think the position is different. Let's take the oil and gas industry for an example. The oil price is very high at the moment, and so there is a large pipeline of new petrochemical projects going to come under bid and under construction. So there's a lot of work around. So again, very different considerations apply in those projects. And so I think the test for the existence of disputes on those projects is determined rather by how the project went, rather than by any received wisdom that hard times generate claims and disputes.
Well, you've spoken at FIDIC conferences in the Far East, the Middle East and Europe just in the last few months, as well obviously as day-to-day experience in practice. Are you encountering changing attitudes towards resolution of major disputes?
Well, at one level, there will always have to be a final means for resolving disputes, and that final means remains international arbitration. And the reason for that is clear. Arbitral awards are enforceable easily and widely across the globe under the New York Convention. If you compare that with litigation, the scene is very different because there is no comparable means of enforcing a court judgment. So parties continue to choose international arbitration as their means for the final resolution of disputes. Where I do think there has been a change is that parties are now seeking to resolve disputes at a much earlier stage. And the way they are seeking to do that is by use of means of alternative dispute resolution. Now, the particular technique that they can use can vary. On the one hand, at one extent of the spectrum, you can have the use of structured negotiations. You can also slightly more formally have the use of mediation or an early neutral evaluation, and more formally still, or most formally, you can have the use of a dispute board. But again, in all of these cases, they point to the fact that the parties are seeking to resolve disputes early so that they can get on with their commercial relationship.
And these trends that you perceive, are they replicated globally, would you say, or do you see regional differences in them?
I think there are significant regional differences. For example, in Asia, there is much emphasis placed on the resolution of disputes by negotiation through some form of structural process. In Southern Africa, there is significant use of dispute boards, be they to make recommendations or whether they make binding decisions. But then again, in Central and Eastern Europe, the position is very often different. For example, in my session tomorrow, Michał Soboks is going to tell us that in Poland, as an example, where a FIDIC contract is used, the dispute adjudication provisions are replaced by reference to an engineer. So again, I do think that there are significant regional differences.
Well, at conferences like this, you and the other speakers share your expertise. Do you find that you benefit from them yourself?
Oh, of course. Absolutely. I mean, you learn probably as much as you give in these conferences. For example, I thought that Siobhan Fahey and Chris Seppler's session on the new FIDIC subcontract this morning was very useful and very informative. Equally, I'm looking forward to the next session today, which will be about the use of FIDIC in emerging markets. So you always learn a great deal at these conferences.
And looking forward, to 2012. What's on the horizon in international construction circles and FIDIC in particular?
Well, I don't think there can be any doubt about this in international construction. The most important development will be the issue of the new forms of FIDIC contract. Now, of course, we've heard today from Sven Poulsen and Aisha Nadar about the work that they are doing on the FIDIC's update task force, but I have to say, we have to look back and think, well, the FIDIC contracts were last issued in 1999. I can tell you that the industry is keenly awaiting a form of FIDIC contract for use in the 21st century.
And will these new developments mean a new edition of FIDIC contracts law and practice?
I have to say, I think all these new developments, when the new contracts come out, will mean that a new edition of that book is essential.